This podcast is brought to you by the School of Advanced Study, University of London.
Okay, good evening everybody, and welcome to this seminar, which is part of the Refugee Law Initiative seminar series on Europe, which, as you can imagine, quite topical at the moment. For those of you who don't know me, I'm David Cantor, I'm the Director of the Refugee Law Initiative, and we're really very privileged this evening to have with us Madeline Garlick, who's going to be addressing us on solidarity or self-interest, the EU's common asylum policy, between politics and desperation. And with that intriguing title, I think you get a sense of Madeline's long experience in working in this field. Madeline, of course, like the other speakers in this series, brings something special to the series itself. She's not only a doctoral affiliate at the Refugee Law Initiative and a doctoral student doing her PhD in the very final stages of her PhD, I think, in Nijmegen University, but she also has spent many years as the coordinator of the EU office of UNHCR in Brussels, and now heads up the protection policy and legal advice section of UNHCR in Geneva. I should emphasise, however, that Madeline is speaking in a purely personal capacity here this evening. So I'd be very grateful if you could keep that in mind, and certainly not attribute any comments that she makes to UNHCR, if you're so minded to take notes. I'd be grateful also if you could keep your questions to the very, very end. Madeline will be speaking about 45 minutes, and after that we'll have time for lots of questions and discussion. So without further ado, I'll hand over to Madeline. It's a great pleasure to have you.
Thank you, David. Stand up, it's all right. So I don't have to wear a microphone, which is a great relief. But I'd like to thank you and the Refugee Law Initiative, David, for inviting me tonight. It's a pleasure to be here, and it's a privilege to be speaking to such an experienced and a diverse group as well. And I want to speak to you this evening indeed about solidarity or self-interest in the context of the EU's common European asylum system. I'm going to be focusing in particular on the theme of responsibility, sharing and solidarity, an issue that's been much discussed over recent months, which is often referred to, but on which there is little clarity and perhaps even less agreement amongst EU member states and institutions. I'm going to also juxtapose that against the idea of self-interest, something which we are increasingly seeing driving the policies of member states. I'm going to ask the question as to whether or not really these are the choices which EU member states face now as they look at the future of their approach to asylum. Whether or not they should remain within the common European asylum system and seek to provide support and help to each other through its basic premises, or whether or not they should, as some states have clearly expressed the will, and through their actions have demonstrated their readiness to pursue what they perceive as their own self-interest, potentially to the detriment of other member states. We've seen a lot of politics over the last months in the asylum sphere, but we've also seen incredible human desperation. We've seen destitution, we've seen poverty, we've seen sickness, we've seen malnourishment, and all of this not a long way away from where we sit, as is often the case. It's often been the case in recent history, but within the EU and at its borders. So clearly, we are facing an enormous challenge, not only in legal and political terms, but also in very human terms. Before I go into the substance, I want to first begin with a quote from somebody who knows a bit about Europe and a bit about refugees, we would hope. The recently finished former High Commissioner for Refugees, Antonio Guterres, who last year at a conference spoke about the fact that we cannot deter people fleeing for their lives. They will come, and the choice is how well we will manage their arrival and how humanely. And I think this is a salient quote because it emphasises that states have political choices. And that's important because some of the discourse that we hear, amongst EU politicians in particular, seems to suggest they see themselves as the hapless victims of outside forces over which they exert no control. But, in fact, they do and have been making choices with respect to how they respond to this. And they have, in many cases, been in the direction of interdiction and deterrence measures. That kind of approach negates the idea that states also have had a significant role in responding or failing to respond to the Syrian refugee crisis, which has been what has driven, of course, many of the movements that we've seen in a number of member states recently. It also negates the very foreseeable nature of the large-scale arrivals that we have seen in recent months in a number of member states. The Syria crisis has been ongoing since approximately 2011, and with increasing pressure on countries in the border nearby Syria, it was entirely predictable that the European Union at a certain point would need to deal with significantly increased arrivals. I think that's my telephone, so before it distracts anybody else further, I was
Quite enjoying that, actually.
Yes, it's quite relaxing, isn't it? Ironically, I think it's actually my alarm clock. So there you are. I promise not to go to sleep. And not to put you to sleep either. Here we are. Okay, so what I hope to deal with then this evening roughly falls under 4 headings. I want to firstly talk about the idea of asylum crisis. What is it, and do we have one? I want to talk about the concepts of solidarity and responsibility sharing. What are they, and do we have them? I want to talk about a few key aspects of the common European asylum system, about which some of you, I'm sure, know a great deal, but in particular about some of the recent pressures it's experienced that have really served as the impetus and compulsion for the Commission to put forward some radical new ideas. And then I want to talk about future prospects, and that I hope will flow then into a discussion where I'd like to hear from you and where I'm sure that there will be other questions and views that you might like to express in response to what I have to say. But first of all, on the idea of crisis. Are we in a crisis? Well, we certainly are in terms of the impact on individual people, some of whom have died of exposure in the last few days at some EU member states' borders. Clearly, in operational, infrastructural terms, there are a number of member states that are struggling with the weight of arrivals that they're unable to deal with. We see clearly a political stalemate, which could develop into a very serious crisis that could have impacts that reverberate far beyond the asylum sphere into many other aspects of EU governance. In numerical terms, there is no denying that the numbers are dramatic. They have increased very significantly over recent years in the EU overall, and for some member states, they are beyond the levels that these member states have ever experienced before. Austria, for example, is a state that's experienced thousands arriving on one day in particular at different points over last year. Bulgaria, similarly, numbers that it's never seen before in its recorded history. We have then, since 2008, clearly something close to 4 times the number that we have seen until now, arriving in 2015. But at the same time, perhaps it's worth looking back also and recalling that in 1992, we saw in the European Union something close to 700,000 arrivals, something close to what we're dealing with now, at least 2/3, in an EU member state that had only 12 members at that time. It was a dramatic time. It was one in which there weren't the tools that we have available now. There was no asylum migration integration fund at EU level to support states. There was no asylum acquis. There was no European Asylum Support Office. And the response was not well managed in many respects. But that experience informed a lot of the thinking that went into designing the system that was put in place subsequently, and which should therefore have contained tools and standards which should have enabled the EU to cope more effectively with future high levels of arrivals. Another factor that perhaps helps to put this a little bit in perspective, we have Frontex, which has given us figures, these are only for 2014, of irregular entries that don't include asylum claims, numbered at around 170,000. And beside that, we have Frontex's number for the total numbers of arrivals, people who arrive regularly, tourists, labour migrants, travellers coming in and out of the European Union, close to a staggering 200 million in the course of a year. And it's interesting to see that because, of course, if one looks at the media and political discussions about the challenges of the problems caused by irregular migration, it really is such a minuscule fraction of the entry and exit through the European Union, which is seen, by and large, as a very good and necessary thing for our lives here. It's also important to, of course, recall the global context. We had, in 2015, figures from UNHCR that showed us that Turkey on the EU's doorstep, was hosting something close to 1.9 million refugees, mostly from Syria. Pakistan, further afield, 1.5 million, including mainly Afghans, and then other countries behind it with very high numbers. Jordan, with 654,000, was hosting more refugees than the entire European Union received in asylum application numbers in 2014. So this again puts, I think, what we're dealing with here in the EU in something of perspective. It's also perhaps worth recalling that UNHCR also emphasises that some 90% of the world's refugees are hosted in developing countries, and that this is a number which has increased steadily over the last decades. So when Europe talks about the crisis it's facing, it also needs to be borne in mind that it is not alone, that the challenges around responding to refugees are a much wider problem than that which faces our society alone. So at a conceptual level then, the idea of crisis, not something that's legally defined anywhere in the European Union legal framework, nor even in policy documents in any authoritative relevant way. But we have had, interestingly, last year for the first time, a legislative proposal put forward for a permanent relocation measure, a support arrangement which is designed to be triggered when a member state receives a significant number of asylum seekers extended beyond its capacity, and that proposal contains an attempt at a definition of crisis, and it may not be what we expect, because it talks about a crisis as something which jeopardises the application of the Dublin system. The Dublin system being the system devised to allocate responsibility to one member state for the determination of an asylum claim made in the European Union. So the reference point is not human rights violations, although it is of course been confirmed by the European Court of Human Rights as occurring in EU member states with respect to asylum seekers. It's not about individual hardship or even breaches of EU law. The reference point is the functioning of Dublin, which highlights perhaps the degree of importance that is still being placed on the Dublin system, despite its many criticisms that fall from many corners. In terms of the magnitude of the so-called crisis that would trigger the operation of this permanent relocation system, the Commission has proposed a definition which says that this must be something which could place extreme pressure even on a well-prepared asylum system, functioning in line with all relevant aspects of EU law. Why was the threshold set so high? The answer to that is because member states, it would appear, were very concerned not to be putting in place a solidarity mechanism, a support mechanism, which would provide assistance too readily or too swiftly, particularly to states which perhaps had not invested sufficiently in developing and putting in place robust asylum systems that would be able to cope without support in most cases. It's meant to ensure that free riders don't get to benefit from EU support automatically without having made efforts themselves. But it actually raises the question then in objective terms about what then can this mechanism bring to states that don't have well-prepared asylum systems functioning in line with law. If they're not going to be able to use this, then how is it going to achieve its goal? Okay, so just zooming back from the EU level, then I want to talk very quickly about the idea of solidarity as it emerges in international law and discourse. And again, it's something that's frequently invoked, but rarely unpacked or explained or defined. We have the UN General Assembly, which in the year 2000 talked about solidarity as a fundamental value, essential to dealings between states in international relations. And something that meant that global challenges must be managed in a way distributing the costs and burdens fairly in accordance with basic principles of equity and social justice. This was adopted as part of the Millennium Declaration. But of course, UN General Assembly resolutions are not binding international law. They are generally perceived as soft law, which can inform the interpretation and the understanding of binding treaties. But we have, of course, here then solidarity being referred to and acknowledged as a fundamental value and not a binding obligation. The 1951 Convention does not refer explicitly to solidarity or to responsibility sharing, but it does talk about the needs for states to cooperate. It talks about the fact that where asylum may place unduly heavy burdens on certain countries, and given its inherently international character, being asylum being a phenomenon that is required when people cross borders, that there is a need for international cooperation. Now, this is included in the preamble to the Convention, again, not part of the substantive binding provisions of the Convention itself, and without further definition or explanation of how this should work. So we have enticing, exhortatory, encouraging sentiments expressed, but do we really have the tools to be able to ensure that these are put into practice effectively? So shifting to the EU framework then. We had in 1999, when the Common European Asylum System was first established, when it was decided that asylum matters would be regulated at EU level, heads of state and government which adopted the temporary conclusions which explicitly said that the aim was a system that would operate in line with the Geneva Convention and which would respond to humanitarian needs on the basis of solidarity. And then 10 years later, in the Lisbon Treaty, the Treaty on the Functioning of the European Union, for the first time an explicit binding obligation in primary level, in primary EU law, which refers to solidarity. Article 80 of the Treaty on the Functioning of the EU requires that asylum, migration and border policies should be governed by the principle of solidarity and fair sharing of responsibility, including its financial aspects, and that appropriate measures should be taken to give effect to this. But again, we have no further definition in the treaty. We have no judgment until now of the Court of Justice interpreting how this should be applied. And we have very divergent views amongst member states around what solidarity should mean and when it should be extended. I want now to shift then in more concrete terms to two instruments which have close links to the idea of solidarity in EU law. One which was designed to give effect to this principle in the first round of asylum legislation. The first instrument to be adopted, in fact, in the EU Asylum Acquis in 2001, the Temporary Protection Directive. And this was based on the provision in the Amsterdam Treaty, which preceded Article 80 of EU, and was designed specifically to ensure that there would be a means of sharing responsibilities amongst member states. The Temporary Protection Directive was put in place to provide for a mechanism for the EU to respond in case of a so-called mass influx, defined in the directive as being the arrival in one or more EU member states of a large number of displaced people from a particular region or country, whether their arrival was spontaneous or aided by humanitarian evacuation. And this provided for those people to receive immediate access to member states' territory and to a form of protection which entailed relatively high levels of rights, immediate rights to work, to family reunification with family members within the European Union, some things that were not later granted to asylum seekers under the Reception Conditions Directive. And all of this without having to go through an exhaustive asylum claim determination, just for the purposes of giving them immediate access to temporary refuge. Now, importantly, that directive provided for a system of financial assistance and also required member states to notify each other of their capacity to receive additional asylum, temporary protection beneficiaries in case this system were to be applied. And it foresaw that those people might be shared out amongst the member states in order to relieve some of the pressures on those that had received the largest numbers during the mass influx. But interestingly, there was no binding obligation included in that directive upon member states to agree to receive people. There was an obligation to notify other member states of their capacity, but of course the member state would be defining its capacity by itself, if they choose to define it in a very restricted way. And it would not be required necessarily to take people from other states. So arguably a system that was likely to experience some gaps. And over the years that followed, we, of course, unfortunately observed that it was never actually invoked. There were a number of occasions where it was discussed, the arrival of large numbers of Iraqi asylum seekers in Sweden and other Scandinavian countries in 2008, 2009, the Arab Spring, when large numbers of people arrived in the first few months of 2011 in Italy, and then, of course, most recently in the context of the Syria arrivals crisis. But member states have never been prepared to apply this directive. And many people talk about why that is, but the overwhelming reason seems to be there is a fear that making available these high levels of entitlements to people would serve as a so-called pull factor that would attract significantly more people from the affected country or region in order to come to the European Union. I want to speak briefly about the Dublin Regulation, not because this is intended as a responsibility sharing mechanism, perhaps to the contrary. Dublin is designed to define which member state would be responsible in the case of an asylum claim made by someone who has connections to more than one member state. And that should be one responsible member state only who should deal with the claim. And there's a set of criteria that it defines, which are those which, based on which that responsibility is determined. And even though the criteria first and foremost require member states to bring together family members of the same member state to have their claims determined together, the criterion that is overwhelmingly applied in the majority of cases is that relation to the first state through which the person entered the EU by irregular means. This is something one can prove. This is something where evidence is rarely disputed. It's possible to demonstrate through fingerprints that a person has come. And so, for better or for worse, this has been the criteria that is most frequently used in Dublin. Dublin over the years has been described as a cornerstone of the common European asylum system. Member states insisting on the need for this in order to enable the entire common European asylum system to function. But there are some member states who, over time, and more recently in particular, have argued that it in fact serves to propose a disproportionate burden on those states that are at the external frontiers of the Union because of the application of this first state of entry criterion. Other member states dispute this, pointing to the fact that the highest absolute numbers of asylum claims are registered in states in the north and west of the European Union. But regardless of whether you believe that Dublin does in fact serve to impose additional burdens on external border states, it is widely acknowledged that it was never designed to share responsibility out in an equitable way. The criteria have no reference to member states' capacity or size or ability to absorb or deal with significant numbers of asylum seekers. So it's a problematic instrument from a solidarity viewpoint, both in principle as well, arguably, as in practice. So, looking at what we've seen over the last couple of years, I think we all have to agree that what we have experienced by way of arrival numbers, both at maritime frontiers, but increasingly in the last year also at the EU's land borders, have been pressures that have demonstrated that the common European asylum system either doesn't have the tools or is not being implemented in a way which enables it to manage what asylum seekers in a way that would ensure full respect for their rights. The last few years have seen progressive increases in the numbers of people coming by sea. We had in this last month alone, up until the beginning of February of this year, 62,000 people arriving by sea in the midst of winter, something that bodes ill for arrival numbers throughout the course of the summer period when the waters are calm. We've also seen a significant climb in the numbers of people who've tragically lost their lives at sea. The figures you have there are believed to be a significant underestimate, given many deaths go unreported. But it's interesting to note that these tragedies have at least served to bring the issue into very stark focus. Last April, when some 800 people are estimated to have died in one horrific incident close to Lampedusa, we saw the EU heads of state and government prepared to meet on 2 days' notice for the first time ever to talk about migration and asylum. They proposed at that time that the European Commission should come forward with a package of measures designed to address this phenomenon, which should include better mechanisms to strengthen asylum systems, but which sought to emphasise very clearly also the member states' interests in reinforcing their frontiers. We've then, of course, seen also in the course of the last 12 months very significant arrivals along the so-called Western Balkan route, including a number of a very significant number of people who have not been prepared to claim asylum, although they come from refugee-producing countries, which are subsequently also often found to claim asylum elsewhere, something that has suggested that they don't necessarily have faith in the systems of some of the member states at the external borders. But all of this has added indeed to the sense of urgency to approach this challenge with some new tools. So the European Commission in May and September of last year has come forward with two proposals for so-called emergency relocation measures. And this has been put forward on the basis of a special provision in the Treaty on the Functioning of the EU, which allows for measures to be taken in an exceptional way, to be decided without consultation of the European Parliament, and which allows adoption of measures which can suspend other instruments of secondary EU law, and which would therefore, in this case, temporarily suspend Dublin for the concerned people. And the relocation proposals, the two of them together, foresee the relocation of some 160,000 asylum seekers. And these should be people who come from particular nationalities who are defined as being prima facie in need of protection. Now, that is to be judged by the recognition rate across the European Union as a whole. The groups that fall into the relevant 75% bracket that the Commission has defined are Syrians, Eritreans, and Iraqis. So 160,000 Syrians, Eritreans, and Iraqis to be relocated from Italy and Greece to other member states. It was initially proposed that this relocation should take place on the basis of a so-called distribution key. That is a formula that was designed to take into account member states' geographical size, their population size, their relative economic strength, judged on the basis of GDP, on unemployment rates, and other things, as well as the numbers of asylum seekers, refugees and resettled refugees that states had accommodated over recent years, effectively recognising previous contributions to sharing responsibility for asylum in the European Union. That aspect of the proposal, interestingly, was not taken up in the final decision adopted by the Council. Although it was decided to proceed with relocation, this was done on the basis of a negotiated set of figures for the people in question, inherently demonstrated that the member state was not ready to sign up to a formula which foresaw the distribution of responsibilities in a way that would be seen as equitable, based on objective, verifiable factors concerning member states' attributes. Financial support was also foreseen to encourage and to facilitate the application of relocation. But interestingly as well, there was a provision put in the mechanism which allowed member states to opt out of receiving asylum seekers. And this would require member states instead, if they were ready to pay in a certain contribution, judged by reference of their GDP, to then choose not to receive asylum seekers under the quota that the distribution key would have allocated to them. This aspect, I should say, has been a particularly controversial one, because many critics have argued that it shouldn't be possible for states to buy their way out of their protection responsibilities. And this raised very serious questions about the possibility that some states would wish to place so much emphasis and priority on requiring others to take asylum seekers that they would be prepared to pay substantial amounts of money. It also raises the question, of course, what if a very significant number of member states chose to do that? We would be left then to take the asylum seekers in. Some other important features of the relocation mechanism: it foresaw specific conditions being attached to the provision of support to the member states benefiting from relocation. They should be prepared to agree to certain specific capacity building measures to strengthen their asylum systems, but also critically there are systems for registering and identifying asylum seekers upon arrival. And fingerprinting was a very contentious issue in this, it having been alleged over past months that both Italy and Greece have been refraining from taking the fingerprints of asylum seekers by force, thereby not registering asylum seekers in the Eurodac database, and perhaps therefore being less likely then to be found responsible under Dublin. So in order to ensure that these registration and identification processes will be undertaken, the relocation proposal includes a requirement that these beneficiary states should host so-called hotspots. These are facilities that are at or close to their external borders, which will be staffed by officials from other member states, from Frontex, from Europol, from the European Asylum Support Office, which are designed to help in registering and receiving asylum seekers and migrants, but also facilitating the application of the relocation process. Interestingly, the proposal contains no provision for requesting or seeking the consent of the asylum seekers to being relocated under this scheme. There is no provision, as was foreseen in the Temporary Protection Directive, as was foreseen and applied in past relocation pilot projects, for the person to be asked with which state they have connections and to which state they might be prepared to go. And this has been particularly controversial amongst civil society and others who have argued, first of all, this doesn't respect human dignity and arguably human rights, but also this could call into question the sustainability of the system. If people are going to be sent to countries to which they don't want to go, does not the risk remain that they're going to do what they're doing right now and move on irregularly to another member state where they believe they have better prospects of integration and support? It's worth mentioning that Hungary was also initially named as a state that should benefit from relocation. It was proposed by the Commission in its September communication that Hungary should be able to benefit from 54,000 places offered by other member states. But in October of last year, Hungary declined to take part in the scheme. And it attributed its decision to two reasons. First of all, arguing that this would not solve its problem. Indeed, Hungary received something close to 200,000 arrivals last year, with the relocation of 54 of them helped address its problem. It would have contributed, certainly. But the second reason that it cited was that it did not consider itself a frontline state, because it maintained that a lot of those people who were coming to Hungary and entering via its borders with Serbia had previously come through Greece, and it didn't want to be grouped with Greece as a sub-country that should be responsible for dealing with their initial arrival. Some other people have suggested that perhaps Hungary also was reluctant to take part because it wasn't ready to sign up to the commitments to strengthen its registration, its asylum, its reception, and its integration capacity that would have come as a condition for benefiting from relocation. Some other people also suggested that Hungary might have difficulty finding 54,000 asylum seekers because Hungary had been seeing a large proportion of those who had come into its borders last year moving on within a very, very short space of time. So the Council finally adopted this proposal, but as I said, without the distribution key mechanism, which some would say was its really the most important solidarity-related responsibility sharing feature. And it was adopted without the agreement of all member states. There was Hungary and Czech Republic and Slovak Republic that opposed it. Poland, which was usually a part of that group, in fact, at the last minute changed its position and agreed to go. So for the first time in the history of the common European asylum system, we've had a legal measure adopted without unanimity, which is indeed an indication of the seriousness of the divisions that have clearly emerged now within member states. There's been a great many questions raised about the operation of this system so far, about the hotspots in particular, which indeed have so far only managed to relocate 322 people out of the intended 160,000. Also about the way in which procedures are being conducted at the hotspots, some people fearing that what really is going on is a very quick and perhaps not particularly rigorous nationality assessment process, rather than a process simply of identifying, first of all, who is an asylum seeker, and secondly, ensuring that they be referred to the asylum process, as EU law entitles them to do. And also questions raised about whether or not this is in fact disempowering, perhaps interfering with, perhaps ensuring that responsibility will be imposed very particularly on the external border states without other member states necessarily being prepared or asked to take their fair share. I mentioned very quickly then also the permanent relocation scheme that has been proposed but as yet not agreed. And this was a second proposal put forward in September by the Commission, which foresees, apart from the emergency measure for 160,000 people in the short term now, this foresees that there should be a permanent scheme put in place which could be triggered, in theory, at any time when a so-called crisis would be found to occur. And so that this means in case of a future eventuality where member states came under particular pressure as defined, or experienced crisis as defined, in that, as like I mentioned earlier in this evening, then it should be possible for calls for help through relocation. And this is interestingly part of the Dublin Regulation. And so it seems to be very clearly a message that the Commission is communicating that Dublin is here to stay, and we'll only make exceptions for it in rare cases where we think it might be needed. Other features of the permanent scheme are very similar to those of the emergency scheme. So questions again are raised about some aspects of those that may or may not prove to be viable, as we'll see in the experience of the months to come of the attempts to implement emergency relocation. So what have we seen by way of reactions to these proposals? Well, I mentioned the Parliament, which doesn't actually have a say on the adoption of the emergency measure. It has expressed objections to the idea that asylum seekers can't express their consent, let alone preferences, in the course of the scheme. They've also argued that this is not going to be enough to help the EU deal with the challenge on the scale that it is facing now. But they've effectively said that it's worth trying and it's better than nothing. Similarly, UNHCR and civil society have given the relocation idea a cautious welcome, but have also notably spoken up about some of the problems they're seeing in implementation. As for particular member states, interestingly, we've seen that member states that have been prepared to overwhelmingly support this idea are the ones that were already receiving the largest numbers of people spontaneously in any case. So Germany, as by far the largest recipient of asylum claims in 2015, nonetheless fully supported the idea and expressed its readiness to take 12,000 people from Italy and Greece as part of the relocation arrangement. States that expressed reluctance to do so, by and large, with the exception perhaps of Hungary, are states which have relatively small numbers of asylum seekers, and evidently the ambition of keeping things that way. So, what is the discussion we're having now about all of this? Well, first of all, about the pace of its implementation, as I've said, and the pace also, I think, of the measures being taken, or the readiness being shown by member states to make available the places that they have committed to offer. We have something like 4,200 offers on the table altogether, it seems, out of the 160,000 that should come. Interestingly also, one of the reasons perhaps for the delay is that member states have been slow in putting forward the seconded officials that the European Asylum Support Office has asked for to staff the hotspots, which could be part of the problem. Concerns again expressed about the idea that states can provide a financial contribution in exchange for not receiving asylum seekers seem to be contrary to the idea that all states should be taking a fair share of their legal responsibility for hosting people and providing protection in the terms of the Geneva Convention, rather than simply paying money in. The idea that this also objectifies and reduces asylum seekers to something that is less than the individuals they are with rights, and treats them as something that can be commodified. The process of selection of beneficiaries has been criticised, including the decision to decide who benefits from relocation based on recognition rates. It's a well-known fact that recognition rates for asylum seekers vary greatly across the European Union, and that the 75% figure probably means that there are some member states who have very high recognition rates, but some that are recognising people in a very small number of cases. Is it therefore a valid and objective measure of who really needs protection? And then the allocation process itself. The questions around whether or not it's really going to be sustainable to allocate people to states for which they have not expressed a preference. In recognition of this weakness around the legislative proposal, we have the European Commission and EASO that have made it very clear that they are seeking, in the course of the implementation of the relocation measure, to take account of people's preferences and to match individual asylum seekers with particular member states that they'd like to go to. But we're also seeing, as perhaps another problem with the system, significant numbers of Iraqis, Eritreans and Syrians who are not applying, not requesting relocation at all because the system seems to be taking such a long time. And significantly, although matching is taking place in practice to the extent possible, it's not part of the legal proposal, which means that it's not something that is guaranteed or has legal certainty. So, that brings us the question, to the question, of course, of where to from here. What is it that we need to achieve at EU level in order to come out of the deadlock we seem to find now? Well, it seems clear from my perspective and that of many other observers that we need a system that actually provides effective access to the legal standards and to the rights that member states have signed up to, not only in international law, but which they have also enshrined in the European Union legal framework. And we need to see effective solidarity and fairness amongst states. But at the same time, this needs to be a system which does encourage states to do their best to operate well-functioning asylum systems rather than sitting back and waiting for the European Union to come in with mechanisms to provide them with help. It's generally agreed by many experts that we need to have more coherent and more consistent enforcement of the standards which are in place. Arguably, one of the big reasons why we face the problems we do on the scale we do today is because there was never sufficient implementation of the asylum directives that were adopted over the course of the last 10 years, and member states were effectively allowed to operate with systems that didn't have the capacity to cope in a flexible way with the kinds of pressures that they would ultimately come to experience. The Commission has pledged to do more, to bring actions in court against the member states for failing to comply with their obligations, and there's no doubt that that has to be a part of the way forward. It's also increasingly accepted now that there needs to be fundamental reassessment of the aims and operations of the Dublin system. Over the last weeks, we've seen the European Commission coming out and saying that it really needs to be a very thorough reassessment of its basic principles, something that they have not said in the past until the very end of last year. The Commission is undertaking an evaluation of the Dublin system now, and I think we can expect some proposals over the course of the next few months. And it is arguable that these need to be proposals that don't allocate responsibility on a random basis, with no reference to capacity, but really in a way that does acknowledge member states have different levels of ability to absorb and deal with asylum claims. Does there need to be more power at EU level? Well, the political forces that are criticising the system we have in place at the moment would say no. But they're also not refusing to accept EU funding support, not only in the asylum sphere, but in many other areas of EU policy. In fact, there are some that are saying that we should be thinking very hard about visiting consequences of non-compliance and non-cooperation in the asylum sphere upon member states across other areas of policy and financial support, regional funds, structural funds, because indeed there are very significant parts of the asylum acquis that some member states are not ready to comply with, but it's arguable that one can't have simply the benefits of EU membership without them being ready to accept some of its responsibilities. Do we need also, at this point in time, however, to be reassessing and rethinking the current European asylum system's orientations overall? There's some people who very controversially are saying that what we've put in place is a system which is a fair weather system, able to manage when conditions are not too demanding, or at least it should be able to if it was being implemented properly. But do we need systems then that can deal more swiftly and more rapidly with asylum claims? In different parts of the world, there are many countries where refugees are dealt with without going through individual status determinations, so-called prima facie refugee recognition systems for some nationalities. It's not something that any EU member state has ever used until now, but one wonders whether or not we need to be thinking quite radically in different ways about how the system should operate to cope with the kinds of numbers that we're facing now. So it's clear that we do need to think again about some of the tools we have now. And it's clear also that member states need to find a way to agree on how they're going to proceed from here. I asked at the beginning whether or not the choice was between solidarity or self-interest. I think that's not a choice, because I think that member states can seek to pursue their perceived self-interest by refusing to cooperate and work with other member states and to find ways to collectively and collaboratively to deal with the asylum challenge, are not going to address that problem in the longer term through unilateral measures either. So I would argue that we need solidarity, we need to do it properly, and we need to do it very urgently.